Hello everyone, I am Assistant Professor Jayendra Patel from Mechanical Engineering Department, Mahatma Gandhi Institute of Technical Education and Research Center, Navsari. This is the 11th lecture and this is the second part of our topic Fundamental Duties. So this is the last lecture on this particular topic. In the previous lecture, we discussed about the fundamental duties, the origin of the fundamental duties. We said that कि भाई fundamental duties जो है वो basically available है part number 4A में. Okay, and basically it contained in only one article, that is article number 51A. Okay. Secondly, we understood that कि भाई fundamental duties were basically not added initially in the constitution, but they were added by the 42nd Amendment Act, and further one more duty was added in the 86th Amendment Act in 2002. Okay, and the inspiration of the same was got from the USSR. Okay, so basically अब जो हम रशिया बोलते हैं उस रशिया के कॉन्स्टिट्यूशन में से हमने इस फंडामेंटल ड्यूटीज को लिया है. Okay. So let us talk further about these fundamental duties. Now, in this particular part, we are going to talk about the legal status of these duties. Now, the question may arise कि भाई हम legal status के बारे में क्यों बात कर रहे हैं? Because it is the legal thing. Because this is available in the constitution, isn't it? But let us understand why we are talking about the legal status or say legality of those duties. One of the most important thing to discuss about the legality is the timing of the introduction of fundamental duties. It was the emergency, internal emergency implemented when those were introduced. That has been the most controversial fact of all of them. Okay. So remember this thing, very first thing, the timing of the introduction. Secondly, the 42nd Amendment Act was like the mini constitution. It has made so much changes in the constitution that were never made before. That's why it is also known as mini constitution, or many times it is known as Indira's constitution, because it was the time of Indira Gandhi government. That's why it is also known as Indira Constitution. So one more time, 42nd Amendment is also known as mini constitution or say Indira Constitution because it has made numbers of changes in the constitution, and this was the time of internal emergency. In the 42nd Amendment, apart from the introduction of the fundamental duties, the amendments were made like fundamental rights become subordinate to the directive principles, restriction of the power of Supreme Court and the High Court to strike down any law which violates the Constitution of India, as well as the establishment of the separation of the power, also tilting the scale of favor of the ruling government. There were numbers of controversial changes made in the 42nd Amendment, and subsequently when the new government came, many of those provisions were either removed by the 43rd or 44th Amendment or they were challenged in the court. अगर आप आगे स्टडी करोगे तो आपके पास नंबर ऑफ लैंडमार्क केसेस आएंगे जो डिफरेंट अमेंडमेंट के अगेंस्ट हो गए. ओके, उनमें से सबसे बड़ा एक लैंडमार्क केस है, दैट इज द मिनर्वा मिल्स लिमिटेड वर्सेस द यूनियन ऑफ इंडिया एंड ओआरएस. ओके, दिस इज द केस दैट बिलोंग्स टू फंडामेंटल ड्यूटीज. If you want to read more, you can read more. Just search on the Google Minerva Mills versus Union of India. You will be able to get the details about the case because it is the very big and the landmark case in the history of the Indian Constitution. So basically, as we discuss, हमने जब discuss किया उसके हिसाब से जो 42nd Amendment था, उसके कई चीजें जो उसके बाद की सरकार है, उसके बाद की सक्सेसिव गवर्नमेंट्स है, उन्होंने रिमूव करने की ट्राई की या फिर कोर्ट्स ने उनको रिमूव करने की कोशिश की बाय द केसेस. बट स्टिल द फंडामेंटल ड्यूटीज वर अवेलेबल. दैट shows the power of the fundamental duties. That shows that fundamental duties should be there in the constitution. Now let us move towards the significance. We will discuss about some of the most important peoples who have gone through the fundamental duties in this section. Very first person was the H.R. Gokhale. Justifying the inclusion of the fundamental duties, H.R. Gokhale, now at that time he was the law minister, okay, law minister. He had stated that in post-independent India, particularly on the eve of emergency in June 1975, a section of people showed no anxiety to fulfill the fundamental obligation of respecting the established legal orders. This is a very serious thing. And a chapter on fundamental duties were therefore meant to have sobering effect on those restless spirits. Those have had a host of anti-national, subversive and unconstitutional agitations in the past. So as per the H.R. Gokhale, he said that on the eve of the emergency, there were some anti-national things going on who were seeking or say intended to erode the base or say foundation of the established government. That means the Congress government. Now, the implementation of fundamental duties shall make such anti-national things serious or say thoughtful towards the constitution and the nation, so that they understand that the laws passed by the government or say ruling parties are the constitutional laws and they should obey them. That's why the fundamental duties are very important. So this was the significance of the fundamental duties. This was the reason why fundamental duties were added as per H.R. Gokhale. Now Indira Gandhi, as we all know, she was the Prime Minister at that time. Now as per the Indira Gandhi, she justified the inclusion of the fundamental duties in the constitution and argued that their inclusion would help to strengthen the democracy. As per her statement, the moral value of the fundamental duties would not be to smoother rights, but to establish a democratic balance by making the people conscious of their duties equally as they are conscious about their rights. So basically इंदिरा गांधी जी का कहना था कि अगर लोग अपने राइट्स के प्रति कॉन्शियस है तो उनको उनकी ड्यूटी के प्रति भी कॉन्शियस होना पड़ेगा. Now at the same time there was an opposition. Okay. Now initially the opposition in the parliament strongly opposed the inclusion of the fundamental duties. Obviously opposition is opposition. Okay, जो अब ये लोग करते हैं वो सेम चीज उस टाइम होगी. So initially opposition strongly opposed because उनका काम ही ये करना. However, the new Janata government headed by the Morarji Desai in the post-emergency period, they did not declare any fundamental duties and unconstitutional. Notably, the new government sought to undo many changes, यानी कि they never tried to revert them back. So basically fundamental duties में उन्होंने कोई भी changes नहीं किए. 42nd amendment में जो भी चीजें available थी वो as it is रहने दी. Though there were some other things removed or say modified in the 43rd and 44th amendment. Okay, जो 42nd amendment में जो भी चीजें हुई थी उनमें से जो भी चीज निकालनी थी वो 43rd and 44th amendment. The 43rd amendment was happened on 1977. 44th amendment happened on 1978. Okay, उनमें उन्होंने निकाल दी but no fundamental duties were removed. Now this particular thing shows the necessity and the desirability of inclusion of the fundamental duties in the constitution, and this particular thing can be further confirmed because there was new fundamental duty added in 2002. Now in 2002 there was a government of Atal Bihari Vajpayee. Okay, and the 86th amendment happens and one more duty is added in the same article. Now let us think about the 86th amendment. As I told you earlier, 86th amendment को हमने पहले भी देखा है. 86th amendment is basically the right to education. Article number 21A, if you remember. Article number 21A, which says that the state shall provide free and compulsory education to all children of the age from 6 to 14. Remember that? If you do not remember, please go and revise the whole lecture. Okay. So basically Article 21A says the state shall provide free and compulsory education to all the children of the age from 6 to 14 years in such manner as the state may by the law determine. And followed by the 21A, one more thing was there in this particular amendment, that is the 11th duty, which says that who is the parent or guardian to provide the opportunity for education to his children, or as the case may be, what between the age of 6 and 14. So basically जो भी पेरेंट्स हैं या फिर जो भी गार्डियन हैं या फिर जिनके पास बच्चों की सिक्योरिटी है, अब बच्चे कौन कौन से 6 to 14 ईयर्स, ना उनकी रिस्पॉन्सिबिलिटी है कि उनको अपॉर्चुनिटी प्रोवाइड करे कि वो पढ़ सके, लिख सके. So I hope this particular thing clears the significance of the fundamental duties. Fundamental duties are not having any kind of legal complications. Okay, but still they are non-enforceable. Now, why they are non-enforceable? Let us understand. So over here, once again, we are coming towards the directive principle of the state policies. Now, in the constitution, the whole thing, the directive principles of the state policies comes under the part 4. Okay, sounds similar. Okay, उसके पहले हमने पढ़ा है part number 3 which deals with the fundamental rights. Okay, इसकी चर्चा हम बाद में भी करेंगे, इसलिए मैं यहीं पर बोल रहा हूं. This is the part number 3 fundamental rights, part number 4 directive principles of the state policies, and the extension of the same part number 4A, which is a separate part, which is what? The fundamental duties. Okay, and which is having article number 51A only. Okay, now try to understand this thing. This is the part number 4, which is the directive principle of the state policies. What we understood previously कि भाई directive principle of the state policies क्या है? These are the part of Indian Constitution ideals which are meant to be kept in mind by the state when it formulate any policy or enact any law. So basically it is like a duties of the state. Now this particular section is non-enforceable, यानी कि स्टेट की ड्यूटीज जो है उनको नॉन एनफोर्सेबल बनाया गया है. दैट मीन्स अगर स्टेट चाहे, उसकी कैपेसिटी हो तो वो उसे फॉलो कर सकता है, बट अगर ना फॉलो करे तो दैट इज नॉन जस्टिसेबल. दैट मीन्स वी कैन नॉट टेक दिस पर्टिकुलर थिंग टू द सुप्रीम कोर्ट. अगर स्टेट्स की ड्यूटीज नॉन जस्टिसेबल है, दैट मीन्स हमारी जो फंडामेंटल ड्यूटीज है दैट शुड ऑल्सो बी द नॉन जस्टिसेबल ड्यूटीज. अगर हमारी कैपेसिटी है फॉलो करने की तो हम फॉलो करेंगे, बट अगर हमारी कैपेसिटी नहीं है, हमारी कैपेबिलिटीज नहीं है, इन दैट पर्टिकुलर केस वी कैन नॉट बी कंपेल्ड टू फॉलो दोज ड्यूटीज. अंडरस्टूड? सो दिस इज द वेरी फर्स्ट थिंग दैट वी नीड टू नो. And in fact, there is a most common reason to not making these duties enforceable is because the majority of the population being illiterate in India at that particular time when the duties were implemented in the constitution. Okay. Now, in that particular scenario, if the fundamental duties are enforced, it would have resulted causing in the chaos and the harassment among the peoples. बिकॉज मोस्ट ऑफ द पीपल्स को पता ही नहीं था कि कॉन्स्टिट्यूशन क्या है, बिकॉज उन्होंने पढ़ाई ही नहीं की थी. तो इन दैट केस दे कैन नॉट अंडरस्टैंड व्हाट आर दोज फंडामेंटल ड्यूटीज एंड व्हाई टू ओबे देम. द स्टडी और से नोइंग, अंडरस्टैंडिंग इज वेरी इंपॉर्टेंट in the Indian Constitution. Now nowadays, if you talk about today, okay, nowadays we all are learning the Indian Constitution and the government is also trying to avail all about it. Many of the acts or say laws are already there to make some of them justiciable. आपको शायद पता भी नहीं है कि ये particular law इस particular duty को justify करता है. Okay, let us continue towards the next. Now the last thing, lack of proper explanation. Now, आपने भी कई चीजें नोटिस की होगी. In all 11 fundamental duties, there is a lack of explanation. There is no proper explanation, and for different peoples, these duties are liable to be interpreted in many different ways. Moreover, the fundamental duties enlisted is wholly dependent on the performance of the state and the directive principle of the state policies. So that is why these duties are legally not enforceable, which means that if a citizen of India violates any of them, no legal action can be taken against them. Now let us check out the criticism done on the fundamental duty. There are many critics who tells lots of things about the Indian Constitution. And in this section, we will be discussing about the criticism of the Indian Constitution for the fundamental duties. So let us start with the very first thing. The list of duty is not exhaustive as it does not cover other important duties. Like, it does not cover the casting of vote, paying taxes, family planning, and so on. There are many things that are not covered. Okay. And in fact, basically, as we discussed, this particular part, paying tax, this was basically suggested by the Verma Committee itself, but they were not added. Secondly, some of the duties are vague. Now, vague means, let me just tell you, vague means what? They are not clear. Their meaning is not clear. Okay. आप लोगों के ही समझ में आ गया होगा कि 11 फंडामेंटल ड्यूटीज में से कई चीजों का मीनिंग क्लियर नहीं है. They are ambiguous and difficult to understand by the common man. Okay, कॉमन मैन के समझ में नहीं आती कई चीजें इनमें से. फॉर एग्जाम्पल, डिफरेंट इंटरप्रिटेशन कैन बी गिवन फॉर द फ्रेजेस लाइक नोबल आइडियल्स. नोबल आइडियल्स के लिए कई लोगों के पास अलग अलग चीजें होगी. आप अलग चीज बोल सकते हो, कोई दूसरा बंदा कोई अलग चीज बोलेगा. सेम चीज हो गई कॉम्पोजाइट कल्चर. नाउ कॉम्पोजाइट कल्चर के डिफरेंट मीनिंग निकल सकते हैं. साइंटिफिक टेम्पर. नाउ व्हाट डू यू मीन बाय साइंटिफिक टेम्पर? These are the words that are available in the fundamental duties. Just check them out. And there are a number of words like this, which are basically having multiple meanings. So there can be numbers of meaning in the numbers of cultural understanding and so much confusion on those particular words. Thirdly, they have been described by the critics as the code of moral precepts due to their non-justiciable culture. एक प्रकार से बोला जाए तो हिंदी में बोलते हैं तो नैतिकता का उपदेश देती है. कई लोगों को अपने प्रवचन देते सुना होगा कि भैया ये मत करो, इससे पाप लगेगा, ये करो, इससे पुण्य मिलेगा. जिन लोगों को फॉलो करना हो वो करेंगे, जिन लोगों को ना फॉलो करना हो ना करें. सो बेसिकली दीज आर लाइक अ नैतिक उपदेश. दे आर नॉन जस्टिसेबल बाय द नेचर. बट इंटरेस्टिंगली, the Verma Committee had suggested the penalty and the punishment on that particular thing. So ये चीज criticism में आना नहीं चाहिए था. But as it was not implemented, this becomes a criticism. The next thing, their inclusion in the constitution was described by the critics as a superfluous. That means unnecessary inclusion. As per the critics, this is the duties included in the constitution as a fundamental would be performed by the people even though they are not incorporated in the constitution, because they are the moral duties. अगर ये duties fundamental constitution में add ना होती तो भी people उनको follow करते. They are the moral duties. उनको follow करना ही चाहिए. और constitution के अलग अलग part में ये चीज mention की गई है. There is no necessity to add those duties in the constitution specially. Further, the last topic, they should have been added after the part number 3. Now what do you mean by that? I just told you previously, part number 3, ये कौन सा part है? These are the fundamental rights. These are the fundamental rights. As I told you, part number 4 कौन सा है? These are the state policies. That is the duties of the state जो non-justiciable in nature है. And the part number 4A जो amendment होके आया है, that is our fundamental duties. Now try to understand what this critic tried to say अगर वो चीजें फंडामेंटल राइट के एग्जैक्ट नीचे ऐड हुई होती, यानी कि पार्ट नंबर 3A बनाया गया होता, तो बाय सीइंग बोथ साइड बाय साइड दे विल हैव हायर वेटेज, यानी कि फंडामेंटल ड्यूटी का वेटेज ज्यादा होता. बट एज दे आर एडेड आफ्टर द state policies, now state policies are also non-justiciable, and as they are added after the state policies, their weightage has been reduced. After all this thing, there was one more committee. Who is the Verma Committee? Now, Verma means he was the Justice Verma, and this particular committee was constituted in 1998. The basic work of the committee was to create a plan or say strategy to work out for the methodology for the operation on the program, कि जिसकी वजह से आप फंडामेंटल ड्यूटीज को टीचिंग में इनकॉर्पोरेट कर सको, उनको एजुकेशन में डाल सको, इंस्टीट्यूशन में ऐड कर सको, ताकि पीपल को पता चले कि यार बेसिकली व्हाट आर द फंडामेंटल ड्यूटीज. सो बेसिकली during finding out the fundamental duties, they identified the existence of the legal provisions for the implementation of some of the fundamental duties. उन्होंने ढूंढ निकाला कि कौन कौन सी जगह थे पे बेसिकली लॉज बन चुके हैं ऑलरेडी फंडामेंटल ड्यूटीज के बेसिस पे. सो दीज आर द बेसिक्स लॉ दैट आर मेंशन्ड ओवर हियर. ओके, द वेरी फर्स्ट लॉ इज द प्रिवेंशन ऑफ इंसल्ट टू द नेशनल ऑनर एक्ट 1971, which prevents the disrespect to the Constitution of India, the national flag and the national anthem. Second is the various criminal laws in enforce provides for the punishment or encouraging enemy between different sections of the people on ground of language, races, place of birth, religion and so on. Nextly, the protection of the civil right acts. The protection of civil rights come over here. It provides for the punishment for offenses related to the caste and religion. अगर आपने caste, religion related कोई भी offense किया हो तो this will be covered under this particular act. Also, the IPC, Indian Penal Code, declares the imputation and assertion prejudicial to the national integration as a punishable offense. The next is the Unlawful Activities Prevention Act, which provides for the declaration of communal organization as an unlawful association. The next is the Representation of the People's Act 1951, which provides for the disqualification of the members of the parliament or a state legislation for indulging in corrupt practices. What do you mean by indulging in the corrupt practices? Like solicitorily voting on the grounds of religion, or say promoting the enmity between the different section of the people on the ground of caste, race, religion एंड सो एंड सो ऑन. अगर कोई भी पॉलिटिकल पार्टी या पॉलिटिकल पर्सन कुछ ऐसा करता है, देयर इज एन एक्ट विच इज द रिप्रेजेंटेशन ऑफ द पीपल एक्ट 1951 विच इज अगेंस्ट दिस पर्टिकुलर थिंग. द नेक्स्ट इज द वाइल्ड लाइफ प्रोटेक्शन एक्ट दैट डील्स विद द प्रोहिबिशंस इन द ट्रेड फॉर द रेयर एंड एंडेंजर्स स्पीसीज. जो भी रेयर स्पीसीज है या फिर जो भी डेंजर में है वो स्पीसीज को प्रोटेक्ट करने के लिए ये पर्टिकुलर प्लान बनाया गया है. एंड द लास्ट वन इज द फॉरेस्ट कंजर्वेशन एक्ट 1980 दैट चेक्स द indiscriminate deforestation and the diversion of the forest land for the non-forest purpose. So basically Verma Committee के हिसाब से these all are the acts that basically represents the fundamental duties या फिर fundamental duties को protect करते हैं. So this was the Verma Committee and this is the end of our lecture. So this is the end of this topic. In the next lecture we will start with the directive principles of the state policies.